Hi, welcome to week 3, and we're talking about legislation and legal issues as they affect selection and recruitment for new people to a firm, and how actually that is done, and what the legal and legislation issues are that directly affect recruitment and selection. Firstly, before we get started, I'd like to just make a few comments on the forums and the great participation from some of the students there. And a particular forum post that I'll refer you to is from Alicia Casey, her post on the 13th of July, and my response about how to obtain the software required for the PowerPoint presentation for free. And the CQ University provides that software free for students. Also Alicia on the 21st and 22nd, and my response on the 22nd of July regarding referencing the PowerPoint presentation and how that's done and what guide to follow. And should there be a reference list? Yes, they should, and it should be on slide 15. And also from Megan Brooker, about what a HR system is. That's on the 29th of July, and my response on the 30th of July, and also the great contribution of Emily as well. That's great. I'll expect students to read the forums. There's very good information on there from students' questions about the forums and how to complete the assessment coming up. So let's get started with legislation and legal issues for week 3. All right. So let's have a look at what this chapter is about initially. And it concerns the legislation that governs work and workers, and it's wide-ranging, this legislation, and it's complicated by the dual parliament system in Australia, where we have state and federal legislation. And that comes about because of the constitution that Australia has, where it defines the powers of the federal body, and it leaves all residual powers to the state to legislate in that area. And due to that, we have both state and federal legislation governing work and workers. All right, so let's have a look at the scope of legislation in Australia. There, as I said, there's both state and federal, and it surrounds recruitment and selection practices, but it's not limited to the following areas where legislators legislate for laws in this area. So the important areas that we're going to look at are equal opportunity, workplace relations, privacy, child-related employment, workplace health and safety, and bullying and psychological testing. These are the areas we're going to concentrate on in this lecture today. So the scope of legislation in Australia continued. Well, we're looking at recruitment and selection practices as they specifically relate to these areas. And so we're going to look at contracts of employment, modern awards, special categories of workers, junior workers, apprentices, part-time and casual workers, and agreements relevant to the job for which recruitment is to occur. And we'll look at those in detail. So, equal opportunity and anti-discrimination legislation. It exists in most states, and certainly at a federal level. If we look at the Queensland example as a bit of a guide, in Queensland you have the Anti-Discrimination Act 1992, which is a state instrument, and then you have federal instruments as well that touch on equal opportunity. So people can lodge complaints in either jurisdiction, but they can't lodge complaints in both. And differences exist across these state instruments from Victoria and New South Wales. They have slightly different names in those areas, and other states have their own instruments as well. So unlawful discrimination has a particular definition, and that definition differs in each region. It's important to understand the jurisdiction that an organisation does business in, and the jurisdiction in which the employees are hired to work for the company. So what is discrimination? Well, in general terms, it is any practice that makes distinction between individuals or groups so as to disadvantage some and advantage others. And not all discrimination is unlawful. For example, you can say, I must have someone for this position in my HR area as a graduate, and they must have a degree qualification. And I'm going to discriminate against all those other employees that do not have qualifications, tertiary qualifications in HR management. Now, that discrimination is not unlawful. It certainly is discrimination. You are discriminating against a group, but it is not unlawful. You may want a graduate to manage your HR function, for example, and if you desire those particular characteristics and they have to have a tertiary qualification, then you are quite able to insist upon that in your selection criteria and your position description. So forms of discrimination that are unlawful include discriminating against people on sex or gender, their marital status, religion, physical impairment, sexuality, race, family responsibilities, pregnancy, political beliefs or activities, intellectual impairment, parenthood age, retirement age, criminal record, breastfeeding, trade union activity, medical record, physical features, and status as a carer. All of those things in various jurisdictions are unlawful. So you need to be careful as a HR manager when writing application forms, providing access to interviews, providing job offers in a written form, terms and conditions of job offers. You can't use discriminatory language in those terms and conditions. You can't always assume that if you're looking for a cleaner, it's a woman. You can't also assume that when you're looking for a police officer, it's a man. So you have to make sure that in those particular conditions, you don't use gender or sex-based language when you're talking about the applicant that you're seeking. Terms and conditions of employers, access to promotion, access to benefits, recruitment, advertising, position descriptions, person specifications and sexual harassment, discrimination against contract workers or discrimination by employment agents. All very important areas where problems can arise with unlawful discrimination. So federal legislation trumps state legislation for any inconsistencies, so the federal legislation will take precedence. Privacy, let's have a look at that. So generally, a contract for employment is not subject to the Federal Privacy Act 1988. However, certain legislation applies to the collection, use and disclosure of employee records. So we need to be careful around privacy so that we ensure that we observe those particular elements of the legislation and make sure we provide for it in our HR systems. And that's a really important question as well about HR systems, and Megan asks what a HR system is in the forum, so I would give that a post a good read. So we need to provide for how personal information will be handled, information about dates of birth, information about superannuation account balances, things like that. We need to make sure that we handle that information correctly and it's not information that's available to everyone. The information that we collect needs to be fair and and not unreasonable. So it's not unreasonable to get an emergency contact. It's not unreasonable to ask for a date of birth. Collecting information from referees, we need to be aware of the Privacy Act when we're talking with previous employers or people who can referee a particular candidate. And we also need to provide individuals with access to personal information when they request it. So we have to be able to hand that information that we have about them on our files, on our systems to them so that they can review it and make sure that it's all correct. So working in Australia is another important area of legal and legislative work that's done in this particular area of worker and worker relationships. So Australian citizens and permanent residents of Australia have an unrestricted right to work in Australia. This right also applies to New Zealand citizens that enter Australia on a valid New Zealand passport. The entitlement of non-citizens to work is regulated by the Migration Act 1958, and authorisation may be required before employing workers from overseas. So you need to be aware of the citizenship status of employees or potential employees so that you don't violate any laws in this area. Working in Australia, you'll need to get proof of status if they're a non-resident or not one of the New Zealand residents. and not all documents that they might provide to you confirm the right to work. So visas that are important here in this category are working holiday visas, work and holiday visas, and long stay business visas. So make sure that you have the required documentation from the employee before you hire them, and you can there is a hotline with the Immigration Department that will help you there. Fair Work Act is a really important act of legislation that governs work and workers. Its full name is Fair Work Act 2009, and it regulates most employees in Australia at the federal level. So it has a safety net of minimum employment conditions called the National Employment Standards that all jobs must provide to workers. It sets out a framework for bargaining in good faith at the enterprise level, so workers for an enterprise can get together and talk to their employer about their conditions, pay and entitlements. Obligations to keep records and provide pay slips are enshrined in this legislation, so employees have a right to their records, have a right to their pay slips and how they've been calculated. There are unfair dismissal laws that are covered by the Fair Work Act, and there's protection from employers and obligations of employers in the Fair Work Act as well. It also sets out the functions of the Fair Work Ombudsman and the Fair Work Commission. So, the Fair Work Act 2009 talks about enterprise agreements. We're just going to talk about those for a moment. Collective workplace agreements or enterprise agreements are a recent trend that has been adopted by business in Australia. It was felt that businesses that wanted to work with employees on their business level would be more beneficial and more economically efficient, and they've certainly been popular and been adopted by a lot of businesses. So, enterprise agreements, it sets out minimum conditions of employment. Modern awards are part of the Fair Work Act, and they're referred to in the Fair Work Act, and you can find information about modern awards at Fair Work Australia. It applies to the whole industries. It's an enterprise agreement, and it's specific to a particular enterprise or project. For example, there is a modern award for hairdressers. There are modern awards for many different types of businesses. So child-related employment is really important. There are specific laws that relate to hiring children for employment, and where jobs involve working with children or coming into contact with children. And the principles of the Anti-Discrimination Acts and privacy are counterbalanced with the duty to protect children in certain situations. So all states and territories have legislation that requires specific child-related occupations to be screened for criminal offences. Privacy and anti-discrimination principles are counterbalanced by the duty to ensure the safety of children. So it's really important that you're aware of these obligations, that you know how these obligations work, and the requirements and documentation that is needed for employers hiring employees to work with children. Employment of children. So if you're thinking about employing children, and the definition of a child is anyone under 18, and certainly places like McDonald's, places that provide workplaces for high school students, they're going to be particularly interested in legislation that concerns the employment of children. And it's for people who are over 15 years of age generally. If they're under 15 years of age, it's generally prohibited throughout Australia. There's going to be some exceptions to that, say with children working on television shows as actors and things like that. Some laws allow for children to work in family businesses, in entertainment or in other light work, not conflicting with school hours. Those state laws must be checked. There's also a whole range of legislation in the Fair Work that talks with unfair dismissal and unlawful dismissal and the seeking of remedies by employees in these particular cases. Unfair dismissal is available if they're not contracted for a fixed period, not engaged for a specific task, not on probation, They've completed the qualifying period of employment, not terminated due to a genuine redundancy, and employed by an employer with more than 15 employees. So unlawful. It's unlawful if an employer terminates an employee's employment for any of these reasons: a temporary absence from work due to illness or injury without due cause, trade union membership or non-membership, engaging in industrial activity, having or exercising a workplace right, race, colour, sex, sexual preference, age, physical or mental disability, marital status, family responsibilities, pregnancy, religion, political opinion, national extraction or social origin. All of these particular areas can be unlawful and are addressed in the Fair Work Act. What I suggest students doing is to have a look at Fair Work Australia and spend some time looking around the website. A HR manager or a graduate in the HR area would spend a lot of time looking at the Fair Work site. A student that I had recently in the course, recently in a HR course, said that she would think that a HR manager would look at legislation perhaps more often than a solicitor. And I think that that's true. I think that HR managers are constantly looking at legislation to know what the rules are. They have questions from employees all the time, and they need to make a decision about what is the appropriate course of action, being guided by legislation and legal statute. And there's also a consideration where you have to understand common law in certain implications as well, as it has for hiring workers and the relationship between employers and employees. So spend a bit of time this week looking at around Fair Work Australia, checking out the modern awards. One way to do this might be to think, how am I currently employed, and determining the things that are relevant to you. That's often a strategy that students employ to understand the material presented here. All right, have a good week, and look at those forum posts. As I said, they're very important. There's lots of information there about preparing your assessment. All right, have a good week.